This opening dispute reveals a problem that appears constantly in family court. Vague parenting language becomes a weapon the moment cooperation disappears. The father arrived believing a holiday
My
violation had
time,
occurred.
and it was easier to let him have the children than to continue to fight because it was the first spring break in 3 years that he was interested in having them.
-19032 DM. We have the parties on that matter present.
Yes,
Yes,
Your
Your
Honor.
Honor. Elliot Blumberg on behalf of Gabrielle St. Clair, who's appearing via Zoom.
Thank you. And Mr. St. Clair, this is your parenting time complaint, is that correct?
That is correct, Your Honor.
All right. And how are you saying the parenting time was violated?
I was supposed to have him for Easter weekend when on Friday, April 3rd, Miss St. Clair messaged me stating that my kids did not want to come with me and she wasn't going to let them come to Easter. So I did not have them for Easter weekend. So she withheld the kids from me on my holiday.
Mr. Blumberg, what would you like to say regarding that?
I'm going to let my client address that, but my understanding is, and what the order provides, is that holiday parenting time is as the parties agree. Clearly, there was not an agreement as to Easter, so I don't see how there could possibly be a violation of the court order.
All right. Let me dig into that. And Mr. St. Clair, are you saying that you guys have a specific holiday schedule?
I do not. I even talked to the FOC and the parenting holiday schedule. Our court states that if we don't agree upon the holiday, it falls back on the standard holiday parenting time.
Your Honor, that's not what the order provides. The order simply says holiday parenting time shall be as the parties agree. There's no fallback language based on the order I saw.
Well, I do see an order from September of 23. So the original order looks like it was just all as agreed. Then I see an order September of 23 where parenting time was changed. That did say that holiday parenting time shall be as they agree. If no agreement is reached, the parties shall default to the 46th Circuit Court holiday guideline. I don't believe that's been changed, but let me double check. Don't see any other orders after that. So, Mr. Blumberg, do you want Ms. St. Clair to speak on this issue?
Sure, Judge. Thank you.
Ms. St. Clair?
Hello.
What would you like to say regarding this parenting time?
Well, to begin with, he had them for spring break, and it was my spring break because he had essentially bullied me into giving up my time. And it was easier to let him have the children than to continue to fight because it was the first spring break in 3 years that he was interested in having them. And then when I got them back on the morning, or I guess it was noon on the 2nd of April. From the moment that they were turned into my care, they told me with no shadow of a doubt, they did not want to return to their father's care for that weekend because of the care they had received during the last weekend of spring break.
What day did they come to you and what day were they supposed to go back?
They came back to me April 2nd at noon, and they were supposed to return April 3rd at, I think it says 6 p.m. for Easter time. And so I had texted Mr. St. Clair, and I was like, I don't know what to do. They were having emotional meltdowns. There is no other way to phrase it. It was heartbreaking to see, and I could not bring myself.
All right, that's okay, man. I'll have some follow-up questions in a second. So, Mr. St. Clair, is it correct that you had the kids, dropped them off to mom, and then you were going to get them back about 24 hours later?
No, my understanding, I had what I got from online under the 46th Circuit. I had the wrong parenting time schedule. So my under condition was I thought I had spring break and Easter. It was brought to my point that I had the wrong version of the parenting time schedule. So I thought it was right-minded to give the kids back, and then it was my Easter, try to just get them back on my parenting time. But yes, I will admit that I had the wrong version of the
So you
parenting
did
time
have
schedule.
several days, the spring break then, correct?
That is correct, Your Honor.
And have you had parenting time since this time, or is parenting time not happening?
I had my weekends. Memorial Day weekend was scheduled for my standard parenting time, but it was Mrs. St. Clair's holiday schedule, which I ended up having the kids.
My question was, since that Easter time, you've had parenting time on your normal weekends?
That is correct.
Okay, all right. All right, well, given all that information, the additional time that Mr. St. Clair had regarding the confusion on spring break, so essentially mom did lose some time there. So given those circumstances and the confusion, I am going to dismiss the show cause complaint. Any questions, Mr. Blumberg?
No, Judge, thank you.
Mr. St. Clair, any questions?
No, Your Honor.
All right, thank you everyone for appearing. You're all set. Me quickly by telling me who filed the parenting time complaint.
Sure. It was filed by the defendant, Mr. Warren, Your Honor. It was filed back on March 12th of this year.
Okay, what is the basis?
The basis was pursuant to the party's old order. So I apologize, Your Honor. I filed my appearance after there had been some litigation on this matter. But I understand there was a temporary order entered by Judge Hesselink way back in December of 25 that held the parenting time would be supervised by the minor children's maternal grandmother, or Miss Warren's mother, and it was only to occur at the grandmother's home. The complaint indicates that the children were taken to Traverse City in March when the old order was still in place for an appointment, contrary to the terms of the order, which indicated that it was only to take place at the grandmother's home and under the grandmother's supervision.
The second matter demonstrates how quickly a parenting complaint can lose momentum when nobody can identify meaningful harm. The alleged violation involved supervised parenting restrictions and a trip to a medical appointment outside the approved location.
I understand there has since been an evidentiary hearing and a new order entered, so this was filed pursuant to that old December order.
Are you seeking some type of remedy?
That's a good question, Your Honor. At this point, I'm not sure, what would make the parties whole, being that this was an old order. And from what I understand, parenting time wasn't missed. It was simply an alleged violation of the order. So if the court were to find that the order were violated, perhaps going forward, if there were violations of the new order, reasonable attorney fees could be awarded if it was required that the attorneys appear for something like this, and an alleged violation was found to have actually occurred.
Are things running smoothly for the most part since that new order got put in place?
I believe so. The parties, from what I understand, are following the order. Mr. Blumberg and I have had continued discussions, and I believe it is, unless I'm told to the contrary.
And Judge, to be clear, I understand that this was under the old order. My client and her mother took the children to a doctor's appointment that Mr. Warren was aware of. And so technically the parenting time didn't take place in the home of the maternal mother, but rather at a doctor's appointment. So, I mean, it seems a bit silly that this was even filed, given the fact that the father knew about it. So we would ask the court to dismiss this. There have been no other problems. The order is even subsequently changed. And so I don't believe there needs to be any finding of contempt at all.
All right, well, given the status of the matter, what happened in the case, it wasn't, she did go to a doctor's appointment, mom was present. I am going to dismiss the show cause complaint.
Thank you.
Thank you for appearing. You're all set.
Thank you, Your Honor.
For next call, the matter of Yvonne Pierce versus Adam Burns, file number 12-14467 DP. Do we have the parties on that matter present?
Yes, Your Honor.
Yes, Your Honor.
All right, and Mr. Parks, you're here on behalf of Mr. Burns?
That's correct, Your Honor. Mr. Burns does appear via Zoom as well.
Okay. Mr. Parks, this is your objection to a child support recommendation, is that correct?
Correct, Your Honor.
All right, and what are the basis of your objections?
Your Honor, if you remember correctly, we were in front of you for an evidentiary hearing back in January. Your Honor had, after hearing testimony and a granted directed verdict on behalf of defendant, but there was an agreement for the oldest child, Mia, to go to Yvonne with a full physical custody, but no legal custody had changed at that point, Your Honor, according to the order. Since then, Mia has been kicked out of school in Flushing. She attended no online sessions after switching to Miss Pierce's residence. And then there was a subsequent recalculation of support. Mia is no longer attending school. And it appears that when front of the court did a calculation for Miss Pierce, they only included one of her incomes. Your Honor remembers at the evidentiary hearing, Miss Pierce had testified that she was working at a golf course as well. And my client understands that she's working a third job as well, including the one that front of the court used for the calculation for support, Your Honor. So we would object on the basis of the income that was reported. And I would note that front of the court on the recommendation did use the incomes from 2025, which I'm assuming did not include Miss Pierce's other employments at that point. So I would ask for the court to reconsider the support that was calculated and get the actual financial income from Miss Pierce for those other two employments that she is working.
So Ms. Pierce, as to Mia's school attendance, what would you like to say?
I had a laptop provided for her, so it's like leading a horse to water. You can't make them drink. I had this here for her to do, and she never got on to do anything. And when she turned 18, she dropped out.
All right, so when she turned 18, she stopped attending school?
Yep.
Okay. All right, so that issue is simple.
I only have two jobs. It's the golf course and the...
Hold on. Let me address, so that issue is simple. So for Mia, we will not order the post-majority support. I think she turned 18 in March.
Yep.
So for Mia, it would end in March. And then as to your employment, ma'am, what would you like to say?
I only work at the Claire Auto Auction and the golf course. I don't know where they think I have a third job at.
All right, what are your jobs?
I work at the Claire Auto Auction and the Wildwood Lakes Golf Course.
All right, is that the financial information that you provided to the friend of the court?
Yes, they know that I'm working at the golf course also, but I did not turn any income in to be calculated.
All right, friend of the court, how did you calculate Ms. Pierce's income?
Ms. Pierce did not provide any updated information, so we did indeed use Michigan quarterly wages that was reported for 2025 because there was no additional information to use.
And Ms. Pierce, did you work both of those jobs last year or something changed recently?
I started at the golf course in...
The judge's handling of the support issue was methodical and reveals how courts evaluate credibility. Instead of accepting either side's version of events, the judge kept returning to documentation. The mother denied having a third job.
November of last year.
Okay. Is that job seasonal, part-time? What are you doing there?
Just weekends right now.
Is that all year round?
In the winter, I work more.
Okay. And then how about the other job? What kind of hours do you work for that job?
That's full time. Okay. I'm 40 hours a week, salary pay.
And your reason, man, you can't provide your most recent pay stubs for both those jobs as well as your 2025.
I can have them turned in on Friday.
Okay. All right. So I will grant the objection. We're going to
Can I
cancel out. Go ahead, man.
request something?
Potentially. What would you
Can
like
I
to say?
request that my child support monthly be taken off what he owes? And back child support to me?
Well, we got to figure out first what your support is.
Okay.
So he owes you back support right now, and it looks like the new order, you're going to owe him support. Is that correct? So you're asking, hey, can we figure out this calculation?
Yes.
All right. Well, I think we'll have to cross that bridge once we figure out what that amount's going to be that you're paying. So, but I do not do new recommendation. I do think that is appropriate when there is that money out there. Sometimes it's a little tricky to figure that all out and how it's going to happen, but it does make sense to try and make that happen.
Okay.
But I will grant the objection. So we'll do a new recommendation. We'll discontinue the post-majority support for the oldest child. So that support would end in March of 26. And then Ms. Pierce, you need to provide your most recent pay stubs for each job, as well as your 2025 W-2s for each job.
Okay.
To the front of the court within 14 days, so they can see if that makes any change to your income, and then if so, make that change.
Okay.
Anything else, Mr. Parks?
No, Your Honor, thank you.
Ms. Pierce, any questions?
No.
All right. Thank you both for appearing. You're all set.
Thank you.
Okay, thank you.
Is that correct?
Yes, Judge, it's actually a twofold motion. One, we're asking the court to extend the breathalyzer testing that Mr. Spreeman was required to undertake before his parenting time. And secondary, we have an issue regarding the summer parenting time that's upcoming. I guess before we get into the actual motions, Judge, do you have 1 hour available to you between now and the end of the school year?
I do not.
Okay.
Not till July 15th.
This case is somewhat complicated by given one of the minor children has some severe epilepsy issues that are not adequately treated by Mr. Spreeman during his parenting time. The summer parenting time would provide him extended periods of a week at a time, and my client has genuine issues concerning his ability to properly treat that condition. And so I don't know what we can do on an interim basis, but at least we can ask Your Honor to continue his equalizer requirements. He has a long sordid history of alcohol consumption, which has led to some criminal convictions. So those are the two issues. Unfortunately, I think it probably would be necessary for you to take some testimony as it relates to the summer parenting time issue.
Ms. Robinson, what would you like to say?
Your Honor, we obviously oppose the motion to extend breathalyzer. That testing is unnecessary. It's been going on for months now. The idea that Mr. Spreeman can't take care of his own child who has had epilepsy for years is absolutely ludicrous. He's been taking care of his kids this entire time when he's with them. We do have mediation already set for this afternoon, so I'm not sure why we're even doing this today. We could have discussed this in mediation today as well. So,
well, because I don't anticipate, given your position, that we're going to be able to resolve these issues. There are property issues that we can talk about this afternoon. We're talking about the welfare of this young child and what we believe to be your client's inability to properly care for him. So again, I don't know what we can do today, except maybe get a 1 hour hearing if it becomes available.
So, Ms. Robinson, is your client, is he currently testing or not testing?
he is currently testing.
When does that stop?
It's supposed to be this month.
It was supposed to be this month. Yeah.
Okay. That's because, well, there was a provision that after 6 months with no positive results, the testing would stop.
I believe it was 6 months, and we made that agreement in September, actually. So we should be at a point where we're done. I believe Mr. Spreeman has continued just because it has been a comfort issue between the parties. But to impose an ongoing obligation is just we don't think that the ongoing obligation is necessary, especially after all this time.
Has he had any positive results?
I am not aware of any positive results. I did not see any come up. I believe one was alleged, but that would have, I would assume, stopped the entire process unless the parties were able to agree to something.
The breathalyzer dispute exposed the danger of assuming compliance without carefully reviewing the record. One side argued testing should end because enough time had passed without problems. The other side responded with specific dates and alleged positive results.
My understanding is very different. My client believes there were 3 positive tests.
The app.
She has them on.
And so does he.
Okay. It did say that if he tests positive, his parenting time would be temporarily suspended.
And it hasn't been.
There's no indication of how long it was to be suspended for. So he had 2 positive results on May 1st, and he had another positive result on January 16th.
That's 2. That's not 3.
I mean, you tested at 8 a.m. and then again at noon with 2 positive results above the legal limit.
Still the same day.
Well, he needs to go 6 months with no positive results. So if there's evidence that it's happened within the last 6 months, he would have to continue. Also, if he tests positive, his time is suspended, but somebody also needs to follow up with that and file motions to address that. So if he has not tested negative for 6 months, then it's going to continue. Otherwise, parenting time could be potentially dealt with.
I apologize for interrupting. It seems like my client's within her rights to withhold parenting time, given the positive testing. Her concern, I don't know if she articulated that for the court. She, what does that mean? A week without parenting time? Or, I mean, she was concerned about continually denying the parenting time when she had the right to do so.
When was the last positive test, did she say?
May 1st.
May 1st.
Ms. Robinson, do you dispute that?
Well, I did. I tested positive May 1st.
Okay. Yep. Apparently, we do not dispute that.
Okay. Well, I mean, I'll let the council handle how they want to handle what the order says, but that's all the language in the order. So certainly testing would have to continue, but there is the other potential issue. But now we're several weeks behind, and it sounds like parent time has happened in between.
Your Honor, if the court were to get a cancellation of another hearing, a 1-hour hearing between now and the end of school, would the court consider sticking us into that?
I would, and then I'm looking at the language of the order, and I see that it started off with some supervised time, and then it went to no longer supervised. What's interesting is the language is beginning Friday, September 25, parenting time will no longer be supervised and will be a standard every other weekend, 6 p.m. Friday to 6 p.m. Sunday. And it talks about the sober link, talks about the potential suspension, and he can get an ETG if he disputes it. Then it says holidays will follow the 46th Circuit Court holiday schedule beginning in September. The defendant must test morning and evening during holiday parenting time. After 6 months, it will no longer be required. I'm not seeing anything about summer parenting time. I don't know if the parties see something or interpret that differently, but that's the language that I see in the order.
I guess it would be our anticipation that the every other weekend would continue during the summer months. I think the Ms. Robinson has a different view than.
Well, I think language-wise that there is a potential question there because I don't see anything that says standard summer schedule. I see the holiday schedule, but I don't see anything that addresses summer. Maybe that was an error in the court's statement of the ruling, but that's what I see as far as the order is concerned. So the parties can interpret that and do what they the standard holiday schedule also includes a summer parenting time schedule, but that is, I guess, a fight to be had.
Maybe we can talk about it this afternoon.
Sure.
Yeah, I don't see any reason we can't.
Do you want me to give you an evidentiary date in case there is no resolution?
Sure.
Do you want a 1 hour then, or do you need something longer?
I mean, if it's just on the issue of summer parenting time and the extension of the breathalyzers, I think we can do it in an hour.
Sure. I mean, it's your motion, and that's what you were seeking, so that's what we'd be looking at.
I
So
mean,
I've got July 5th. I have July 15th at 11 o'clock open.
just get in.
Okay.
July 15th. I'm sorry, what time?
11 o'clock.
I can move some things around.
The hearing closed with a dispute that highlights how much power a few missing words can have in a court order. The parties were suddenly debating summer parenting time because the order clearly addressed weekends, holidays, supervision, and testing, yet appeared less clear regarding summer schedules. That ambiguity created an opening for completely different interpretations. The judge resisted the temptation to immediately choose a winner and instead focused on what the written language actually said. That restraint is important because courts generally prefer clarification through evidence and argument rather than assumptions. By scheduling a future hearing while encouraging mediation, the judge effectively placed responsibility back on the parties. The message was straightforward. If cooperation fails, the court will decide. But until then, both sides have an opportunity to avoid turning a drafting problem into a full-scale litigation battle.